trouble in your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything look smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as you. Hey, Daniel, I'll fix you up for you.
Welcome to the show. Today is Judge Aaron Gauthier, however you want to spell his name, another judge that I respect. So let's get this started. Share screen, 53rd Court. Let me go back to StreamYard and make this bigger. And
Sheboygan, and we are providing public access both in the courtroom and also online. And we have an arraignment in People v. Baker, file 25-7081FH. Counsel, you want to state your appearances for the record, please?
Melissa Goodrich, Sheboygan County Prosecutor.
Thank you, Honor. Ravi Gurumurthy on behalf of Mr. Baker.
All right, good afternoon, and we're here for an arraignment on a charge of delivery of methamphetamine, a 20-year felony. Have you had a chance to review that charging document with your client?
I did, Your Honor. By way of arraignment, we would ask the court to enter a not guilty plea, and we would waive formal reading of the felony complaint, Judge. However, we do have this resolved. If the court's willing to accept a plea and take a plea today, we would tender that plea. I did discuss that plea as well with Mr. Baker. He's willing to go forward and tender that plea. And we did discuss his trial rights as well.
Okay, what's the plea agreement?
Plea agreement is to an added count 2 possession of methamphetamine. Count 1 would be dismissed. There's also a sentence agreement for a treatment under 7411 status. And there is a $100 restitution to SANE.
Okay, very good. And is a forensic center referral requested?
No, sir.
Okay. All right, and I have an amended information adding count 2. Do you consent to the filing and waive the reading?
I do.
Okay, Mr. Baker, you want to enter that plea today, sir?
Yes, Your Honor.
Okay, would you please raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you can put your hand down. Now, how do you pronounce your first name, Mr. Baker?
Elsid?
Okay, are you Elsa Joseph Baker III?
Yes, Your Honor.
Okay, and Mr. Baker, a guilty plea hearing is an important event excuse me, because it includes the waiver of constitutional rights that you have. So I want you to listen carefully. If you have a question for me, go ahead and ask it. If you need some time to talk to your attorney, you just let me know and I'll put you in a breakout room. Do you understand those things?
Yes, Your Honor.
And I have to advise you the maximum penalty for the charge of possession of methamphetamine. It is a felony. It's punishable by a maximum of 10 years and or a $15,000 fine. Do you understand that maximum penalty?
Yes, Your Honor.
Are you on probation or parole anywhere?
No, Your Honor.
Were you on bond for any other case at the time of this incident?
No, not for when this took place, no.
All right. Do you understand if you enter a plea, you won't have a trial and you'll give up the rights that you would have had at trial?
Yes, Your Honor.
I want to remind you of some of the more important of those rights. You have the right to be tried by a jury, and at that trial to be presumed innocent unless and until the prosecutor proves your guilt beyond a reasonable doubt. You'd have the right to have the witnesses against you appear and to question them. You would have the right to present witnesses in your own defense and have me order those folks to show up. You would have the right to testify at your own defense, at your own trial, or to remain silent and not have your silence used against you in any way. Do you understand all those rights?
Yes, Your Honor.
Do you wish to give them up and enter the plea here today?
Yes, Your Honor.
If I accept your plea, you give up any claim that it was caused by threats or by promises beyond the plea agreement. Do you understand that?
Yes, Your Honor.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission by filing an application. But the types of issues you could raise on an appeal after a plea are very limited, much more limited than if you were convicted after trial. Do you understand that?
Yes, Your Honor.
The plea agreement provides in exchange for your plea to possession, the prosecutor will dismiss the delivery count. There's restitution of $100 agreed upon and a sentence agreement for treatment under section 7411 of the Public Health Code, which would be a dismissal if you successfully complete probation. Do you understand the terms of that plea agreement?
Yes, Your Honor.
And that sentence agreement is not binding on me, meaning I don't have to follow it. But if I didn't follow it, you'd be allowed to withdraw your plea. Do you understand that?
Yes, Your Honor.
Now that's unless you engage in some misconduct between now and the sentencing. Let's say you don't show up for court, or you abscond on your bond, you commit a new crime, or you violate conditions of your bond. That type of misconduct could cause you to lose the right to withdraw your plea, even if I didn't give you the 7411. Do you understand that?
Yes, Your Honor.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, Your Honor.
Has anybody threatened you to make you?
No, Your Honor.
Is it your own free choice to enter that plea?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge of possession of methamphetamine?
Guilty, Your Honor.
So, Mr. Baker, back on January 17th of this year, were you in Sheboygan County?
Yes, Your Honor.
And while you were in that county, did you possess the controlled substance methamphetamine?
Yes, Your Honor.
Did you know that you were in possession of that substance?
Yes, Your Honor.
And did you have any lawful authority to possess it?
No, Your Honor.
Mr. Gurmurthy, you satisfied with the factual basis?
I am.
Ms. Goodrich?
Yes.
And Mr. Gurmurthy, are you aware of any other promises, threats, or inducements?
No, sir.
And do you believe I've complied with the court rule?
I do.
Ms. Goodrich, do you agree?
Yes.
All right, Mr. Baker, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense. So I hereby accept your plea. Ms. Goodrich, any objection to continuation of bond?
No objection.
Bond will be continued. I could schedule sentencing, Mr. Gurmuthy, for Tuesday, January 13th in the afternoon. Would that work for you?
Just checking, Judge. I think that will.
Okay, we can schedule that for 1:40 in the afternoon.
Okay.
Now, Mr. Baker, it's your responsibility to contact our probation department and schedule an interview. They can a lot of times do that over the phone or in Zoom. If they need it to be in person, you have to comply with that. But you have to cooperate with that process so they can write a report with recommendations to me on what to do.
Okay.
And then we'll see you in person on January 13th at 1:40 in the afternoon for your sentencing. Do you have any questions for me, sir?
Yes. So do I call the probation officer, like, or the agency today, or?
Yeah, I would try calling him today, and if you need that number, Mr. Gurmuthy can get it to you, or you can contact
Okay,
circuit
yeah.
court staff and we can get it to you.
Okay. Thank
Mr.
you.
Baker, I'm gonna email that to you here in a few minutes.
Okay. Okay. Thank you, sir.
Yep, no problem.
All right. All right, we'll see you then, Mr. Baker.
Yep. Have a good day.
All right, thank you. And Mr. Gurmuthy, I've got Mr. Winger. Let me bring him in here. All right, Mr. Winger, can you hear us? He's answering. You got to unmute yourself
Yeah,
here.
I'm unmuted now. I can hear you, Your Honor.
Okay, great. All right, we have People v. Gavin Wenger, file 25-7079FH. We've got counsel for defendant and defendant both appearing by video from separate locations. Let me know if you need a breakout room. And Mr. Gurmuthy, this is up for docket call. What's our status here?
Your Honor, we have this matter resolved. In my discussions with Mr. Wenger, he's indicated he would take advantage of the offer that was tendered in this matter. The offer is to plead to count one, which is a 5-year felony, and or $5,000 fine. That's possession of a weapon by a prohibited person. Added count 4, operating while intoxicated, which is a 93-day misdemeanor, and then count 5, which is another 93-day misdemeanor, possession of a weapon under the influence. Remaining counts and add 3 would be dismissed. There's also an agreement of a county jail cap.
Okay. And Mr. Winger, is that how you want to proceed today?
It is, Your Honor.
All right, would you please raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can put your hand down. Mr. Wenger, a guilty plea hearing is important because you waive constitutional rights that you have, so please listen. If you have a question, go ahead and ask. I'm happy to answer it. If you need a minute with your lawyer, just let me know. We're happy to create a breakout room for you to talk to him, all right?
All right.
Now, I have to advise you the maximum penalty for the charges that you'd be pleading to. Count 1, possession of a firearm by a prohibited person is a felony punishable by 5 years and or $5,000 fine with mandatory forfeiture of the weapon or device. Count 4, operating while intoxicated, is a 93-day misdemeanor and or a fine of $100 to $500 and or 360 hours of community service. And the court could order rehabilitative programs, vehicle immobilization, and costs of prosecution and emergency response. And count 5, possession of a firearm under the influence, is also a misdemeanor, punishable by 93 days in jail and or a $100 or $500 fine for using or discharging the firearm. $100 fine or $500 if you've used or discharged the firearm, I'm sorry, and mandatory forfeiture of the weapon or device. Do you understand the maximum penalty for those charges?
Yes, Your Honor.
Are you on probation or parole anywhere?
No, sir.
Were you on bond for any other case at the time of this incident?
No, Your Honor, I was not.
Do you understand if you plead guilty, you give up the rights that you would have at trial?
Yes, Your Honor.
I want to remind you of the most important of those rights. You'd have the right to be tried by a jury, and at that trial to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. You'd have the right to have the witnesses against you appear and to question them. You'd have the right to present witnesses in your own defense and have me order them to show up. You'd have the right to testify in your own defense or remain silent and not have your silence used against you. Do you understand those rights?
Yes, Your Honor.
Do you have any questions for me or your lawyer about any of those rights?
Not at this time, no.
Okay, do you wish to waive those rights and enter this plea agreement today?
Yes, Your Honor.
Mr. Winger, if I accept your plea, you give up any claim that it was caused by threats or by promises beyond the plea agreement. Do you understand that?
Yes, sir.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission by filing an application. But the types of issues that you could raise on appeal by application are very limited, much more limited than if you went to trial and were convicted. Do you understand that?
Yes, Your Honor.
All right, the plea agreement provides, as your attorney outlined, in exchange for your plea of guilty to those charges, the remaining charges and the habitual be dismissed. Any weapons seized to be forfeited to the agency that seized them. And there's a sentence agreement for a county jail cap. Do you understand the terms of that agreement?
I do, Your Honor, yes.
And Mr. Winger, that county cap is not binding on me. If I didn't want to follow it, I wouldn't have to. But if I decided I wanted to send you to prison, you would have the right to withdraw your plea because you wouldn't be getting what you bargained for. Do you understand that?
Yes, Your Honor.
Now, there is an important exception to that. I want to make sure you get. If you have any misconduct between now and the sentencing date by either absconding your bond or skipping court, failing to appear, committing a new crime, violating the conditions of your bond, misconduct like that would cause you to lose the right to withdraw your plea, even if I didn't follow the sentence agreement. Do you understand that?
Yes, Your Honor.
All right. Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, sir.
Has anybody threatened you to make you?
No, sir.
Is it your own free choice to enter that plea?
Yes, Your Honor, it is.
All right. Knowing all that, how do you wish to plead to the charge and amended count 1, possession of a firearm by a prohibited person?
Guilty.
How do you wish to plead to the charge in count 4, operating while intoxicated?
Guilty.
And how do you wish to plead to the charge in count 5, possession of a firearm under the influence?
Guilty.
So, Mr. Wenger, back on July 22nd of this year, were you in Sheboygan County?
Yes, I was.
And were you operating a motor vehicle on South River Road, a public highway?
Yes, I was.
Before you operated that vehicle, had you consumed alcoholic beverages?
Yes, I did, Your Honor.
Did you have some contact with law enforcement?
Yes, I did.
And did they give you a test to determine the amount of alcohol in your body?
Yes, they did, Your Honor.
Did that reveal that the amount of alcohol in your body was greater than the legal limit of 0.08?
Yes, sir, it was.
And so your ability to operate that motor vehicle was substantially affected by the consumption of alcohol, would you agree?
Yes, I do agree, Your Honor.
And while you were under the influence of that alcohol, were you in possession of a firearm?
Yes.
Did you have a previous conviction for breaking and entering with intent, a felony crime?
Yes, I did, Your Honor.
And did that render you legally ineligible to possess that firearm?
I believe so, Your Honor.
Okay. Mr. Gurumurthy, are you satisfied with the factual basis?
I am.
Ms. Goodrich?
Yes.
And Mr. Gurumurthy, are you aware of any other promises, threats, or inducements?
No.
And do you believe I fully complied with the requirements of MCR 6.302?
Yes.
Ms. Goodrich, do you agree?
Yes.
All right, Mr. Wenger, I find that your plea is entered knowingly, understandingly, and voluntarily, and that there's a sufficient basis in fact and law to believe that you committed those offenses, so I hereby accept your plea of guilty to them. Ms. Goodrich, do you have any objection to continuation of bond?
No objection.
Okay, bond will be continued. Mr. Winger, you'll have to contact the probation department to have them prepare a pre-sentence report for me. And we could schedule your sentencing for Tuesday afternoon, January 13th at 1:30.
Okay, Your Honor.
Anything further, Mr. Gurmurthy?
No, sir, thank you.
Anything further, Ms. Goodrich?
No, Your Honor, thank you.
Okay, Mr. Winger, we'll see you then.
Okay, have a great day. Thank you guys for your time.
Okay. And is that all you have, Mr. Gurmurthy, today?
That is all I have, Judge. Thank you.
Okay, you have a good day and
You too, sir.
happy Thanksgiving.
Yes, happy Thanksgiving to you and everyone in the court.
Oh, you want to this one. All right, Mr. McLeod, if you want to come forward to the table here, we've got Mr. Keough zooming in. All right, Mr. Keough, can you just confirm for me that you are not driving that motor vehicle? You're a passenger?
That's correct, Judge. I am the passenger in the front seat of the vehicle.
Okay. Wait, is there anybody driving that car?
Yes, there's
Oh,
somebody
okay.
there driving it. Yes.
I didn't see it at first. I did have a lawyer.
There is.
I did have a lawyer zoom in one time from a self-driving vehicle, and that was a little unusual.
No, we're all good,
All right.
Judge. We're safe. We're driving safely. We're good. Thank you.
All right, Mr. McLeod, you're welcome to take a seat, sir. Okay. All right, we're here for People v. Dustin McLeod, file 25-7066FH, here for a docket call. And we also have a show cause to go through. In terms of the docket call, Mr. Keough, where are we at on this case? Is it resolved or ready for trial, or do you guys want another docket call?
We'd like another docket call, Judge, if we could.
Okay. And Mr. McLeod, it is, we did a show cause. It is alleged that you're in contempt of court for violating the conditions of your bond by missing a sober link test. You've got the right to have a hearing on that allegation, where the contempt would need to be proven beyond a reasonable doubt. You have the right to the assistance of Mr. Keough at that hearing. If you were found to be in contempt, I could jail you for up to 93 days or fine you for $7,500 or both. Also, if I believe that you're not complying with the conditions of your bond, I can amend or revoke the conditions of that bond or revoke that bond entirely. Do you understand the rights that you have and the penalties involved, Mr. McLeod?
Yes, sir.
All right, Mr. Keough, would Mr. McLeod like that set for hearing?
Correct. Yes.
Okay. What we can do is you're here on a sentencing on Mr. Texter on Tuesday, December 23. You want me to just add this to when you're here on that?
That'd be perfect, Judge. Thank you.
Okay, so we can schedule this for a docket call and a what I can do is I can schedule it for a status conference on the pending contempt and a docket call, and then let Ms. Goodrich know if you want to have a contested hearing for her to bring witnesses. We'll schedule that for December 23 at 1:20. All right, let me write that down. I did want to get input from counsel. I mean, Mr. McLeod has a right to have a hearing on that, but given the charge as a OWI third, I do have a concern about a missed sober link and wanted to get some input about whether at this point it'd be appropriate to make any changes to the conditions of bond. Ms. Goodrich, do you have any input about that?
Yes, Mr. Keough has been in my office to kind of explain the circumstances, and I would not be asking for bond revocation at this time.
Okay, All right, well, I won't tinker with the bond conditions at this point then until we sort that out, and I'll give you guys the space to do that. But Mr. McLeod, I just want you to understand with the charge, and I mean, you're presumed innocent and have a right to a trial, but with the nature of the charge, the bond conditions have public safety as a condition in mind. So I just want to make sure that everybody's assured that you're not consuming alcohol and causing a risk of more problems, okay? All right, anything further, Mr. Keough?
No, Your Honor. Thank you very much.
All right, you have a good day. Safe travels.
Thank you. Happy
all
Thanksgiving to everybody. Thank you.
Okay.
Thank you.
Is Mr. Hilliker present? Yeah. If you want to come out to the table, your attorney is zooming in here. All right, good afternoon, Mr. Grable.
Good afternoon, your judge. Good afternoon, Judge. Happy holidays, by the way.
Oh, you too. All right, up next, we've got People v. Nicholas Hilliker, file 25-7076FH. We've got the prosecutor here in the courtroom, defendant in the courtroom, and defense counsel zooming in with leave of the court. And we're here for a docket call and also a show cause. So as to the show cause, Mr. Hilliker, it's alleged that you are in contempt of court for violating the conditions of your bond by missing some scheduled SoberLink tests on looks like November 10th and October 6th and October 27th. You've got the right to have a hearing on those allegations where your contempt would need to be proven beyond a reasonable doubt. You have the right to the assistance of Mr. Grable at that hearing. If you are found to be in contempt, you could be jailed up to 93 days or fined up to $7,500 or both. Also, if I believe that you're not reasonably complying with the conditions of your bond, I can amend that bond or even revoke it at any time. Mr. Hilliker, do you understand the rights that you have and the penalties in the contempt matter?
Yes, Your Honor.
All right, and Mr. Grable, how does he wish to plead to the contempt? Not guilty at this time?
Well, Your Honor, I think we could resolve the matter. The only one thing, I did review the material, Your Honor. So I guess I would say not guilty, but probably in the next few seconds, we may change that to guilty. The paperwork I'm provided shows a missed test on 11/10 at 10 p.m. and 10/27 at 10 p.m. a missed test as well. I did not get any paperwork for the October 6th. I did get a potential missed test for November 6th. So I'm wondering if that was just a typo. I think that's probably going to be perfunctory because if he missed two tests, I'm not sure it's going to change the court's analysis. So I think we could resolve it today, but I did not see a missed test for October 6th. It was November 6th. Again,
Okay. Well, I guess,
but it's still.
my thought at this point might be if the parties, I guess I'd want input from the parties on this question. If given the nature of the charge being an OWI third and either 2 or 3 missed SoberLinks at the tail end of the day, that raises enough concern that I think I'd want to switch it to change the condition from a SoberLink to an alcohol tether. And that if we just amended the bond to do that, I'm happy to dismiss the contempt citation. I'm not looking for punishment. I'm just looking to assure that we've got public safety protected here and making sure Mr. Hilliker's not drinking.
Your Honor, I had the opportunity to speak to Ms. Goodrich about this exact issue as well as my client, Your Honor. And I mean, we appreciate the courtesy of the court allowing him to switch to the alcohol tether. He's already prepared to do that, to swap the unit out. And absolutely, we would certainly stipulate to that, Your Honor, and we're ready to move forward with that on that particular issue. I think it makes sense because the court doesn't want excuses. The court wants compliance. The court is trust but verify. Obviously, there were some makeup tests in there and so forth, but it doesn't really matter. The court wants complete compliance, not 98% compliance. They want 100% compliance. And I think that would facilitate that by switching.
Okay, Ms. Goodrich, does that sound good to you?
Yes, stipulate
Okay.
to that.
Okay, so what I'll do is I'm going to go ahead and dismiss the contempt citation. So we're not going to be looking at jail for that, but I will amend the bond to require Mr. Hilliker that you obtain an alcohol tether within 48 hours. So that's a physical unit on your ankle, and it detects alcohol through the sweat. If you tamper with that, that's not only a bond violation, but a separate crime to tamper with those devices. And I don't want you to tell me what was going on with the missed test, but I just want to tell you, if what was going on is you were skipping the last test and doing some maintenance drinking or something, and you have a concern about your ability to stop, then talk to Mr. Grable. I would be interested in helping you get into treatment rather than jail. So don't tell me what was going on, but if that's going on, please be honest with Mr. Grable about how we can best move forward with that, all right?
Yes, Your Honor.
All right, Mr. Grable, in terms of the docket call, is the case resolved or ready for trial, or would you like another docket call scheduled?
Well, Your Honor, I think I've just submitted paperwork today for at least possible admission to recovery court. And I know, to be fair to Ms. Goodrich, she just got that document, but I think he's a good candidate for the recovery court. I think she's going to screen him, and I think if the court wants to set another docket call, but I assume we may be able to move forward before that date once her office has an opportunity to screen this. I do believe he fulfills the criteria necessary for enrollment of that at a shorter later date.
Okay. Are you available for a docket call, and Zoom appearance would be fine on Tuesday, December 23rd?
1 second, Your Honor. I have my calendar here. I'm sure I am. Let me look real quick, Your Honor. I am available on that date. What time, Your Honor?
How about 1:40 in the afternoon?
No, and I appreciate the court allowing me to appear by Zoom. It's appreciated, Your Honor. I am.
All right. So, Mr. Hilliker, what we're going to do is have you come back for a docket call on December 23rd at 1:40 in the afternoon. If you've got that alcohol tether in place, I mean, we need to get proof of that within 48 hours. Yeah, so contact the court staff, make sure we get proof of that. If you don't get that, I'll probably be doing a warrant for your arrest. But if you do get that done, your attorney is free to Zoom in for that next hearing, as are you. You can talk with your attorney about whether you want to be in person or Zoom, okay?
Okay, thank you.
All right, anything further, Mr. Grable?
Just to clarify, Judge, he should go to, I don't know if you refer to his pretrial services or just the court clerk, the staff, so he can effectuate that. He was planning on having that done forthwith immediately before he leaves.
Yeah, no, we actually don't have a pretrial services division with the court. There is, I think the company that you are getting the sober link through might also have alcohol tethers. I'm not
I
sure.
think they do.
Okay, check with them.
We'll
And if
contact
they
them,
don't,
right?
then call Mr. Grable and he can contact court and we can get you pointed in the right direction.
We'll get
Maybe
you.
we're noting, Your Honor, that the 48-hour time period does encompass the court closure on Thursday, so he wouldn't be able to report that to the,
Oh,
so we have to
yeah,
get done
okay.
probably quickly.
Just about to
Okay,
address
yeah,
that.
yeah, get it done right away.
Okay,
Get it done right away.
I will be on it.
Okay,
We're going to call as soon as court is done. I'm going to have him, we're going to contact them this afternoon to see their earliest hookup. Judge, if there is an issue where, well, I assume they could put it on hopefully by tomorrow, but if there is a problem, then obviously he'll use the sober link. But I mean, we're going to call them today, immediately.
yeah, okay, yeah, use the sober link until it's on. I mean, try to get it on before the court closure, but obviously if, I don't know, I mean, if I mean, then we'd have to wait and deal with it Monday, right?
Oh, we're going to call right now this afternoon. We're not going to wait.
Okay, all right, have a great day, Mr. Grable.
I
You're all set,
appreciate
Mr.
your
Hill.
time. Thank you
Thanks,
again,
Sean.
Judge. Thank you.
Yeah.
Bye-bye.
All right, and Ms. Kay Hogaboom, we can call people to Strack. And that's file 25-7021FH. Counsel, you want to place your appearances on the record?
Melissa Goodrich, Wayne County Prosecutor.
Good afternoon, Your Honor. Diane K. Hubble on behalf of and with Ms. Strack, who's seated to my right.
All right, good afternoon. And we're here for sentencing on a CSC 4th degree, 2-year misdemeanor with a guideline range of 0 to 6 months. Have you had a chance to review the pre-sentence report and recommendations with your client?
I have, Your Honor.
Any additions or corrections or scoring challenges?
None, Your Honor.
Ms. Goodrich from the People.
No, Your Honor.
Ms. Kay Hogaboom, anything you want to say on behalf of your client?
Your Honor, I've reviewed the recommendations of my client. We're in favor of their adoption.
Okay, Ms. Strack, you don't have to say anything today, but you're welcome to. Is there anything you want to tell me or no? Oh, she's shaking her head no, and that's fine. Ms. Goodrich, any recommendations from the people?
Also in agreement with the recommendations.
All right. Ms. Strack, in this case, I think obviously this was poor decision-making on your part. But I don't think that putting you in jail is an answer here. And you're already on probation in Emmett County, or?
Correct.
Okay. So I don't think we need to place you on probation here at all. So I'm going to follow the recommendations. And you do have to comply with the requirements of the Registration Act. And I think the Department of Corrections already made sure that she's begun that registration. And in terms of the sentence, it'll just be fines and costs. There's $130 as a crime victims assessment and $68 in state costs. Given Ms. Strack's circumstances with, I think, some housing instability and a young child, I'm not going to assess court costs, so I'm going to waive that. So that's a total of $198. If you're not able to pay that today, you can set up a payment plan with the court staff, okay? Now, Ms. Strack, if you want to appeal from that, from your conviction or sentence or both, you can do so by filing an application to the Court of Appeals. If you wanted a lawyer appointed, you'd have to ask within 6 months, and when we do so, we're going to hand you a piece of paper explaining that appeal process and ask you to initial one copy so that we have a record we gave it to you. The other one is for you to fill out if you want to take an appeal. Do you have any questions for me?
No, sir.
Okay, good luck to you.
Thanks.
Good luck, okay?
Who's this?
You're welcome, my dear. Take care of yourself. This is your copy.
And I'm sorry, I see the
That one?
attorney
Okay,
is
yeah.
just zooming in.
Okay, perfect.
Sir.
That's fine.
Okay, Lexi, take care of yourself. Call me if you have questions about the recording, okay?
Absolutely.
Because you know that one thing you have to worry about is if you don't do it correct, right, you put me in trouble in the future. So give me a call if you don't understand anything about it, okay?
Thank you so much.
Thank you, Ms. Gaylor.
Thank you.
Thank
sir.
you, Judge. Have a happy Thanksgiving.
You too. All right, then next we'll call people be Pamela Garza, file 25-7075 FH. All right, and people be Garza, can council please state your appearances beginning with people?
Melissa Goodrich, Boone County Prosecutor.
Good afternoon, Your Honor. Adam Kianoszewski appearing for Rustin Schisler on behalf of Ms. Garza.
Okay, good afternoon. And Ms. Garza's here in the courtroom, and we're here for a docket call, and I had revoked bond, and we sort of continued the contempt sentencing, so that's on the docket as well. Where are we at in terms of resolution of the case, Ms. Goodrich?
Your Honor, I believe we do have a resolution. We're talking to Mr. Schisler. I pleaded count 1, possession cocaine, dismiss count 2, remand count 3, the OWI, back to district court for misdemeanor plea taking to an impaired, and then a sentence agreement for 7411, that's
Okay.
count 1.
Okay, Mr. Kazanuski, is that how Ms. Garza wishes to proceed there?
That's my understanding, Your Honor.
Okay. The only thing, and Ms. Goodrich did alert me to the remand before the break, and I talked to my court administrator, and I would not do that. I know that maybe district court said that's the way they would like it. I would not do that.
Okay.
Because I'd be really concerned that then sometime down the future, when somebody's trying to see what record Ms. Garza has, the district court number would be the FY, and that is the same case as our FH file. And so I just don't know how in the world that's going to shake out in lien. It would show an arrest segment in a file that's now suppressed. So I won't do that. So you can dismiss it, and then you'd have to reissue it and have her plead to that way.
Correct.
So I don't know if that affects the timeline of whether you want, I mean, we can.
We did previously have it written up that way, so if Mr. Schisler's office could submit that one, and we can resubmit that to the court then that way.
Okay. Mr. Kanuszewski, do you understand what I'm getting at, and any objection to that way? I mean, it's maybe 6 one way, half a dozen for the other in terms of Ms. Garza's perspective, It's just a different process, just to make sure we have clear record keeping.
Nope, I understand, and I'm in agreement with that.
Okay, so I'll go ahead and proceed to take the plea just to count one, and then you can just submit the amended plea agreement, and then
We'll submit a nollie.
yeah, I suppose the nollie will be either at the sentencing, or if you want to move that forward, you can just submit the nollie as to the count three, and then get that process rolling
Okay.
before the sentencing.
We'll probably do it that way.
Okay. All right. So Ms. Garza, do you understand? We're talking about, how you're going to end up pleading to an impaired driving. But all you're going to do, that's going to happen in the district court.
Okay.
But what you're going to do here, if you want to, is plead guilty to the possession of cocaine with a sentence agreement for 7411, meaning the case would be dismissed if you successfully complete probation, the possession of cocaine.
Yeah.
Do you understand that?
Yes, sir. Yes, sir.
Do you want to go forward with that?
Yes, sir.
Okay, would you please stand and raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, you can have a seat. All right, Ms. Garza, guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have, so I want you to listen carefully. If you have a question, ask me. If you need time to talk to your lawyer, you just let us know. We can make that happen. You're offering to plead guilty to count one, which is possession of cocaine. It's a felony punishable by 4 years and or $25,000 fine. Do you understand that maximum penalty?
Yes, sir.
Are you on probation or parole anywhere?
No.
Were you on bond for any other case at the time of this incident?
No, sir.
Do you understand if you plead guilty, you won't have a trial of any kind and you'll be giving up the rights you would have had at trial?
Yes, sir.
All right, I want to remind you of some of the more important of those rights. You'd have the right to be tried by a jury and at that trial to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. You'd have the right to have the witnesses against you appear and to question them. You'd have the right to present witnesses in your own defense and have me order them to show up. And you'd have the right to remain silent and not have your silence used against you or to testify in your own defense. Do you understand those rights?
Yes, sir.
Do you have any questions for me or for your lawyer about any of those rights?
No, sir.
Do you wish to give them up and enter a plea under this agreement?
Yes, sir.
If I accept that plea, you give up any claim that it was caused by threats or by promises beyond the plea agreement. Do you understand that?
Yes, sir.
Also, when you enter a plea, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission. You would do that by filing an application for appeal. The types of issues that you could raise on an appeal would be very limited after a plea, much more limited than if you went to trial and were convicted. Do you understand that?
Yes, sir.
All right, the plea agreement provides in exchange for your plea of count one, possession of cocaine, and a plea in the district court to a newly issued charge for impaired driving. Then there would be a sentence agreement for 7411 as to count one, and the other charge, the contraband, would be dismissed. Do you understand the terms of that plea agreement?
Yes.
Understand that sentencing agreement for 7411 is not binding on me. I don't have to follow it. But if I didn't follow it, you'd be allowed to withdraw your plea. Do you understand that?
Yeah.
Okay, because you wouldn't be getting what you bargained for. Does that make sense?
Yeah.
Okay, there is an important exception to that. If you engage in misconduct between now and then, let's say you absconded bond or violated bond or committed a new crime, then by your misconduct, you would lose the right to withdraw the plea, even if I didn't follow the sentence agreement. Do you understand that?
Yes, sir.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, sir.
Has anybody threatened you?
No.
Is it your own free choice to enter that plea?
Yes, sir.
Knowing all this, how do you wish to plead to the charge in count one, possession of cocaine?
Guilty.
So Ms. Garza, back on September 6th of this year, were you in Sheboygan County?
Yes.
Did you have some contact with law enforcement?
Yes, sir.
And were you in possession of the controlled substance cocaine?
Yes, sir.
Did you know that you were in possession of that substance?
Yes, sir.
And did you have any lawful authority to possess it? You're not a doctor or
Oh, no.
pharmacist, and
No,
it wasn't
sir.
prescribed to you.
No, sir.
In rare circumstances, believe it or not, it actually is prescribed. So
No.
you had no lawful authority to possess it?
No, sir.
Okay. Mr. Kanishewski, are you satisfied with that factual basis?
I am, Your Honor.
Ms. Goodrich?
Yes.
And counsel, are you aware of any other promises, threats, or inducements?
None, Your Honor.
Your Honor.
Okay, and do you believe I've complied with the court rule, Ms. Goodrich?
Yes.
Mr. Kanishewski, you agree?
I do.
All right, Ms. Garza, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of the offense, so I hereby accept your plea. I guess, Ms. Goodrich, what are we doing here on the contempt sentencing, on the bond situation? Any plans or thoughts on that?
Your Honor, last I knew, they were unable to get her into inpatient yet. I was hoping that could take place, just based on her own statements of struggling with substance abuse, and I hate to see her sabotage her 7411 by releasing her.
Right, okay. Well, Mr. Kanishewski, my thought will be to continue the contempt sentencing. What I said last time is, I don't want to, for example, enter a judgment of contempt that says like 93 days in jail, and then you find her a bed somewhere and she's got to serve that sentence. To just set the contempt sentencing for the same time as the underlying sentence, keep her bond revoked because she was drinking a couple times on this bond. But then if you were to find inpatient treatment for her, I would certainly sign a stipulation for furlough for treatment.
So you're not open to reinstating her bond so she can get back to work, Your Honor? It's either inpatient or sit. Is that what I'm hearing?
Yeah, I think so, because she was drinking twice while on bond, and she was drunk driving, and I just, I'm not sure that she's able to just white knuckle it and stop without getting some treatment. And I don't want to have to bury somebody because she, can't get it together.
Okay, Your Honor.
All right, so what we'll do is we'll schedule this for sentencing on January 13th at 1:20 in the afternoon. That'll be the sentencing and the contempt sentencing. But again, Ms. Garza, if you or your attorneys are able to get inpatient treatment for you somewhere, we'll let you do that. All right. Anything further from the people?
No, Your Honor, thank you.
Anything further from the defense?
No, Your Honor, thank you.
Okay. All right. We'll see you then. All right, and that'll bring us to will be Marissa Johnson. This is file 25-7033FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Swain County Prosecutor.
James Gilbert here on behalf of Ms. Johnson.
Okay. All right, Mr. Johnson, I thought you were traveling and zooming in. Okay. Oh, you're here just on Mr. Rosencrantz?
Yes, Your Honor.
Is he present?
Yes, yes.
Okay, let's go ahead and do that so we can get Mr. Johnson as well. So, all right, so let's call people v. Ted Rosencrantz. All right, this is file 25-7082FH. We've got the prosecuting attorney, Ms. Goodrich here, Mr. Johnson for defense, and the defendant is present as well. All right, and Mr. Johnson, have you had a chance to review the charging document with your client?
Yes, Your Honor.
And do you or he wish to have its allegations read?
No, Your Honor.
And how does he wish to plead to those charges?
I'm not guilty, Your Honor.
All right, we'll enter a plea of not guilty. Is a forensic center referral requested?
No, Your Honor.
What would be the estimated length of trial?
In 2 days.
Okay. Would this be appropriate for So we might have it here. Are you available on the afternoon of Tuesday, December 23rd?
Just set something this morning. I just set an exam for 12 p.m.
Here?
No, in Ann Arbor.
Yeah, oh, okay, we don't want to do that then. All right. What about January 13th then? Would that work?
I have 2 jury trials scheduled in Shiawassee.
Well,
I don't think,
what about a Zoom appearance in the morning on the 23rd of December?
say that'll work. And I was gonna say the 13th. I think I'm in the 15s on both those dates. So I don't think it's likely that either of my trials will go.
Oh, okay,
But,
okay. Do you want to do the 23rd in the morning on Zoom?
Yeah, 23rd, yes, Sean.
Okay. How about 9:50 a.m.?
Yes, sir.
Yeah. All right, so Mr. Rosencrantz, your next court date is going to be Tuesday, December 23rd, be at 9:50 a.m. You're welcome to appear in person or by video conference and consult with Mr. Johnson about how you want to proceed with that, okay?
Yes, sir.
All right, anything further from the defense?
Yes, Your Honor, I do plan to file a motion to quash
Okay.
on this case. Will the court want to hear that on the 23rd? I mean, it's
Yeah, I
not
can
gonna be
do
a
that.
lot.
In fact, why don't we do it at 9:30 instead of 9:50? And then that'll give us plenty of time before the 10 o'clock docket to hear that motion. And
Does the court know if the transcripts are ready?
I don't. Did you order them or?
I believe so. I'm
Okay.
not sure.
Yeah, I don't know. They're not. A copy is not in this file, so I don't know if it is ready. But
I don't think we received them yet. I don't know if they've been ordered.
I'll go downstairs and check.
And if it's not ready in time for you to notice up that motion, feel free to get with my assignment clerk and get another date and stip to adjourn the docket call.
Yes,
It doesn't make sense to do a docket call if we're not able to hear the motion.
Yes, sir.
Okay. Anything else from the defense?
Well, I think there's gonna be another motion in limine. I don't know how the court does it. On Arno cases, I like to file a motion in limine to see what law the court is going to give of the jury. I know under the jury instruction, it does allow for defense to ask for special instructions regarding.
Oh, yeah, yeah. So on R&O, you like to file a motion for basically for a special instruction?
Yes.
Okay.
Will the court want to hear that on the 23rd as well, or closer to trial if this doesn't resolve? Well, I guess.
I'd be happy to hear it at the same time, but if there's a chance the information is going to be quashed, maybe we don't need to do that. So if you want to file them in serial fashion, that's okay with me. But if you want to hear them at the same time, that's fine too.
Yes, sir. Thank you.
Okay. All right. Anything further from the people?
No, thank you.
Okay, we'll see them. Yeah. All right, then we'll recall People v. Johnson. And Johnson present?
She is not. I just received a text, Your Honor, from her because I was hoping she was going to get here early. That she's broken down on the side of the road. I know she does live in Alpena, and that she's on the telephone with the insurance company. I asked her to zoom in, so we knew why for her absence. I don't know if she's done that yet.
Okay, she's not on Zoom. We'll pass the case and see what's going on later in the afternoon.
Thank you very much.
Do you need Mr. Colpin out from the jail?
I don't believe I do, Your Honor. We've requested a forensic on him and that order's been, I believe, already filled out and signed.
Okay, so we don't need to submit orders in this case. You're just awaiting forensic eval in the district court
That's correct.
matter. So we want to just adjourn this out.
If we could, Your Honor.
Any objection, Ms. Goodrich?
No objection.
Okay. Well, let's let me put it out to January 13, a couple months, and see where we're at with
That'd be fine, Your
that.
Honor.
Okay, we'll put it for a status conference on January 13th at 2:40. Let's call People v. Sheldon. This is two file numbers, 2019-5876 and 2021-6222. And we've got Mr. Sheldon in court with his attorney, Mr. Gilbert, prosecuting attorney, Ms. Goodrich. And this is a continuation of a show cause for non-payment of fines and costs. Where are we at on that, Mr. Gilbert?
I believe Mr. Sheldon has just made a payment on each of them for $50 each. So that would bring the total on one file down to $35.88 and the other one $373.
All right, and Mr. Sheldon, are you able to continue monthly payments in that regard?
Yes, sir.
Okay, I think because we have had some pretty significant problems with getting you to appear, I don't want to or getting you to keep up with payments once you made one. I don't know that at this point I want to dismiss the contempt and just see how you do. I think my thought is to adjourn it a couple months, see if you make the December and the January payment, and at least one of the files be taken care of completely.
Yeah, I'm trying to pay it all completely here real soon, hopefully, so.
Okay, so why don't we have you come back on January 13th at 2:50 in the afternoon.
January 15th.
January 13th at 2:50. All right, and we'll see what the status is then.
Okay, thank you, sir.
You're very welcome.
Do you have, that's not until later, so we're waiting then for,
I don't know, Your Honor, if you want to address Mr. Wapner McPeak.
hang on, let me in the live stream here. Plead to the RNO, the other charge, and the habitual be dismissed. Do you understand that?
Yes.
Has anybody promised you anything else?
No.
Has anybody threatened you?
No.
Is it your own free choice to enter that plea?
Yes.
Knowing all that, how do you wish to plead with the charge of resisting or obstructing the police?
Guilty.
So, Ms. Givens, back in October of 2024, were you in Sheboygan County?
Yes.
And did you encounter a Trooper Halleck with the Michigan State Police?
Yes.
Was he in uniform? You knew he was a police officer?
Yes.
And did you fail to obey a lawful order that he gave you?
Yes.
What did he tell you to do? But like, what did you do to resist or disobey him?
I was pulling away.
Okay, as he was trying to arrest you?
Yes,
Okay. And that happened in Sheboygan County?
yes.
Mr. Gilbert, you satisfied with that factual basis?
I am, thank you.
Ms. Goodrich?
Yes.
Mr. Gilbert, you aware of any other promises, threats, or inducements?
I am not.
Ms. Goodrich?
No, Your Honor.
Mr. Gilbert, have I complied with the courtroom?
I believe you have. Thank
Ms.
you.
Goodrich?
Yes.
Any objection to waiving pre-sentence and proceeding to immediate sentencing?
None at all, Your Honor. Thank you.
Ms.
No
Goodrich?
objection.
Mr. Gilbert, anything you'd like to say on your client's behalf?
Yes, Your Honor. I would ask that the court consider time served. She has been incarcerated or being evaluated by the forensic unit for some time. So I believe she's in excess of 400 days on this offense. So I'd ask that the court assess time served at this time. Thank you.
Okay, Ms. Givens, you don't have to tell me anything about your sentence, but you're welcome to. Is there anything you want to tell me or no?
No.
Ms. Goodrich, any recommendations?
Yes, Your Honor, the jail list reflects 402 days of incarceration. I would just ask for that to be ordered with time served.
All right, well, Ms. Givens, I think I'm going to follow those recommendations. There's the lowest fines and costs I can do is $68 minimum state cost and $130 as a crime victims assessment for a total of $198. You can set up a payment plan with my staff to take care of that. And I'll order that Ms. Givens serve 12 months in the Sheboygan County Jail with credit for 12 months previously served. So then we'll get that paperwork done so you can be released.
Okay.
And then you can file an appeal if you wish. And if you wanted a lawyer, I'd give you one, but you have to ask within 6 months. We're going to hand you a piece of paper about that and ask you to initial one copy. The other one is for you to fill out if you do want to appeal. Do you have any questions for me, Ms. Givens?
No.
Okay, good luck to you.
Thank you.
Okay, Keisha, I don't see you.
Thank you.
Okay, bye.
All right, and next we've got people be Camden Hepner, file 25-6921FH. So you want to state your appearances, please? Oh.
James Gilbert here on behalf of Mr. Hefner.
All right, and we're here for sentencing on charge of malicious destruction of personal property over $1,000. It's punishable by a maximum of 5 years in prison. The guidelines have been initially scored at 0 to 6 months. Mr. Gilbert, have you had a chance to review that report and recommendation with your client?
Yes, we've reviewed the report and the recommendation with my client. We have no additions or corrections and we have no challenges to scoring.
Mr. Juliet, any additions, corrections, or scoring challenges from the people?
Okay.
Mr. Gilbert, anything you'd like to say on your client's behalf?
Oh, yes, I would point out that Mr. Hefner would like me to, that he has been addressing, I believe there was some, it's reflected that there's pending charges or issues with Mount Pleasant and Saginaw. He has been in contact. I believe Mount Pleasant was resolved and Saginaw is in the process of being resolved. They know where he's at and he's been addressing those items. In addition to that, Your Honor, we asked that the court follow the recommendation. I believe Camden has learned his lesson from this. As the court knows, he does have another pending case, but I think this time in jail has been a very big eye opener. Prior to this, and I know he's conveyed this to me on many occasions, prior to this, he never really had a jail experience. I mean, he's a young man and this is the first one he's really had. And I think it was an eye opener. He's in there with people that he doesn't necessarily want to be around or be like. There was one instance in another case, and I know the court saw the video. When I saw the video, I was very proud of Camden. There was a fight in the cell. What does Camden do? He hightailed it as fast as he could away from that, so he wasn't involved. And there's me watching it as I saw what was happening. I was very proud of what Camden did. That Camden that I knew years ago in the juvenile court probably would have been involved with that. And so I think this has been an eye opener. And he does understand that he has to get his temper under control. He does have a temper issue. But again, the jail has been a very big learning experience. Thank you.
Thank you, Mr. Hefner. You don't have to say anything today, but you're welcome to. Is there anything you want to tell me or no?
No.
Okay, Mr. Juliet, any recommendations from the people?
I would ask the court to follow the recommendation for the probation credit for time served in this case. The defendant's 19 years old and he's already got his first felony. He has significant juvenile history. I remember because I was the prosecutor in most of those cases. Now he's got more pending felonies, so I certainly hope this was not an eye opener. I'm not going to rehash the facts that the court sat through this trial. So I ask the court to follow the recommendations.
All right, well, this is a really hard one, Mr. Hefner. We did have a trial in this case, and this was a very serious offense. When I think about what's an appropriate sentence within a guidelines range, we've actually had some cases today where we think about, well, gee, other conduct that would have been worse would have still been in the same guideline range. And here, other conduct that would have been far less serious would still be in the same guideline range. If you had keyed Mr. Hush's car, you'd be here convicted of the same offense with the same guidelines range. But this was a pretty frightening situation. You were at a outdoor party gathering that had a bunch of young people there, and some of them fueled by alcohol, I'm sure. And then you gather up a crowd of people to go get someone as they're trying to leave in their car. And their car is surrounded while you and others that you have riled up are pounding on it, kicking it, trying to pull them out. And what were you going to do if you got them out? Beat them up. And there's a girl with them in the car. What's going to happen to her? That's a very serious malicious destruction of property case. For anybody inside that car, that'd be a terrifying situation. It's not just you on the outside, it's the other folks that you've rounded up. And then I look at, okay, that's the seriousness of the offense. What about the seriousness of the offender? I know this is your first felony conviction, but you've been busy. In the juvenile court, you had a 2021 MDOP misdemeanor dismissed after a delay. So you're put on probation for destroying somebody's property or damaging somebody's property 4 years ago. Then the next year, receiving, concealing stolen property and a home invasion. And then the next year, 2023, guess what? Another malicious destruction of property misdemeanor. Then you get discharged from juvenile probation in April of 2024. Within 4 months, you commit this malicious destruction of property, a felony, that I consider a very serious event. Then while the case is pending, in October of 2024, you get an assault and battery charge out of Saginaw, for which you're ultimately convicted and get probation. Then in August of 2025, you get a felony resisting obstructing police charge in Isabella County that's scheduled for court next week. And then in September of 2025, back in this county, you're charged with discharging a firearm from a moving motor vehicle, and you're set to be arraigned by me next week. My goodness, I mean, Mr. Hefner, that's a young man that is just out of control, and being on juvenile probation didn't slow you down. Being on felony bond didn't slow you down. So what's it going to take to slow you down? So your lawyer's telling me you sitting 83 days in jail has changed your life, and now you're going to stop doing this stuff. Why should I believe that to be true? Is there anything you got for me today? Like, what have you learned?
That jail isn't somewhere that I would like to be. I need to be there for my son, and that I need to do better in life. And I see that I don't want to be like these people in jail going to prison. I don't want to be. I want to change. I want to do better. I know I have a drinking problem. I need to get like some sort of rehab, some sort of something. I know that. And I reached out to an outpatient, and I was accepted to one. Just depending on what happens here today.
All right. So I honestly don't know what to do, Mr. Hepner. I mean, well, we've got a couple pending contempts for the pending charges. I mean, I'll dismiss both of those pending contempts. We're here for sentencing on this one. The other cases are still pending, so it doesn't make any sense to proceed with those contempts. But then, you know, I'm really torn here with what to do because, you know, I want to make sure that what I'm doing when I'm here on this bench is keeping the folks in town safe. I also am looking at a young man who's 19 years of age. I don't want Mr. Hepner to draw a lesson at 19 that the system only exists to come down on him like a load of bricks. You know, I do want to hold out hope, given his youth, that probation can help. But, you know, that's only going to be if you participate. You know, probation isn't going to make you any better unless you participate in what's going on. So I don't know. I mean, I think I have to kind of combine some things here. So I think taking all these things into account, what I'm going to do, Mr. Hepner, is place you on probation for 2 years as recommended. That's subject to the terms and conditions listed on pages 2 and 3 of the pre-sentence report. I want to highlight some of those conditions for you. You have to complete a substance abuse assessment when you're referred by your field agent, and outpatient or residential substance abuse treatment when you refer. You have to participate in adult education or GED. So we want you to finish your education. We want you to get sober, stay sober, get treatment for that. No contact at all with Mr. Hutch. We want you to get a job, full-time employment, to keep a job. There's a restitution, but that was paid by the co-defendant, so I don't think we can double dip on that. And it'll be up to the co-defendant to sue him for contribution, I think.
I agree.
Okay, so I'm not going to assess any restitution, so that's at zero. It's been paid by the co-defendant. There's a crime victims assessment of $130, court costs of $350, state cost of $68. You have to comply with DNA testing and pay a $60 fee, and there's a monthly supervision fee to the Department of Corrections. I'm going to, Agent Martin, I'm going to add a couple terms of probation because Mr. Hepner's been cruising around without much regard for the community. I wanted to do 100 hours of community service, and I want him to have a curfew. And and at did I say 0 to 9? It was 0 to 6 months. Okay. You know, Mr. Hepner, you are on a fast path to significant incarceration, including prison. So I do think, given the seriousness of this situation and the pattern of behavior that brought you here, I'm going to order that you serve 5 months in the Sheboygan County Jail with credit for 83 days previously served. And that's within the advisory guidelines. I think it is, there's reasonable grounds for incarceration despite the intermediate sanction because of his pattern of behavior up to this case and the pattern of continuing criminal behavior while he was in bond in this case. And Mr. Hepner, you are entitled to appellate review of this conviction and sentence as a matter of right. If you are unable to afford a lawyer, I would appoint one to represent you on appeal. but you must file the request within 42 days after entry of the judgment sentence if you want to appeal by right. We're going to hand you a piece of paper explaining that, ask you to initial one copy, the other one's for you to fill out if you want to appeal. And also you're eligible for early discharge from probation at the halfway point. If you've successfully completed all its terms, we're going to hand you a piece of paper explaining that process. Within 24 hours of your release, I want you contacting your supervising agent, okay? And if you violate probation, you can expect a lot more time from me. All right, good luck, Mr. Hefner. Mr. Gilbert, I do see Ms. Johnson zooming in, so I'm going to bring her
Excellent.
in. All right, Ms. Johnson, can you hear us?
Yeah,
Where are you right now?
on the side of the road between Rogers City and Sheboygan.
Okay, this is People v. Marissa Johnson, file 25-7033 FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Sheboygan County Prosecutor.
And good afternoon, Your Honor. James Gilbert here on behalf of Ms. Johnson.
All right, we have a docket call and also a show cause. Ms. Johnson, it's alleged that you're in contempt of court for violating the conditions of your bond by not calling into the bond line or testing at all. You have the right to have a hearing on those allegations where they need to be proven beyond a reasonable doubt, and the right to the assistance of your attorney. If you are found to be in contempt, I can jail you for 93 days or fine you for $7,500 for both. Also, if you're not complying with the conditions of your bond, I can amend or revoke that bond at any time. Do you understand the rights you have and the penalties involved?
Yes.
Mr. Gilbert, do you know how you wish to proceed on?
At this time, Your Honor, would ask for the hearing. I know that I've sent the information to Ms. Johnson. She has sent me an email back with some explanations. However, there's supposed to be some more documents, and for some reason, her and I are not being
My
able to
email has
exchange.
not gone through at all. I apologize for that. I don't know what's going on. It's my Apple one, so I'm going to try to switch over and see if I can get it through somehow another way, or maybe have a fax number so I can, I don't know, something's got to happen because I have the tests.
I can provide.
So she's saying that she has tested?
She says she has explanations for some of the missed calls and missed tests.
I have
haven't seen
tested
any
though, yes. I'll get those documents all provided.
All right, where are we at on the underlying case, Mr. Gilbert?
Your Honor, we have a plea that I presented to my client. She has asked for some additional discovery, which I have printed out for her. I was hoping she was going to be here today. Obviously, with the breakdown, that didn't happen. And she would like to review that before she decides whether or not to accept the plea. I know this is an old case.
Okay, we're going to set it for trial.
Okay.
We'll set it as a backup to straight on January 8th and 9th. And give counsel 21 days to exchange witness and exhibit lists. We'll come back for a docket call on December 23rd at 2:30. And we'll set it for a status conference on the pending contempt at the same time. All right, so here's what we're doing, Ms. Johnson. Your next trial date, I'm sorry, your next court appearance with me is Tuesday, December 23rd at 2:30 in the afternoon. You have to be present in person. No zooming in. Make sure you get some reliable transportation and get over here for that. I'm going to continue your bond at this point and set the pending contempt for a status conference at that same time. But I want to tell you in no uncertain terms, there should be no missed calls. And there should be no missed tests at all. If there's a single missed call starting today or missed test, I will simply sign a warrant for your arrest. We won't wait for explanations. Do you understand that?
Yes, Your Honor.
All right. And we're scheduling the trial for January 8th and 9th. It'll be a backup that day because straight would have priority. And if this case resolves, that's fine. I'm not giving you a plea cutoff on it, but I just want to get a trial date on the books.
Understand.
Okay. All right. Anything further from the people?
No, Your Honor, thank you.
From the defense?
No, Your Honor, thank you.
Okay. All right. You're all set today, Ms. Johnson.
All right, thank you.
Let's get off the record for a second while I add that.
We're probably going on to the trial docket fairly quick.
All right, can counsel approach? And this will bring us to People v. Keegan Warner, 25-7004 H for sentencing. So you want to state your appearances for the record, please?
Mr. Goodrich, Wayne County Prosecutor.
Dominic F. Andretti Jr., Your Honor, on behalf of Mr. Warner, seated to my right.
All right, and we're here for sentencing that's been adjourned a couple of times. All right, so Mr. Andriaki, have you had a chance to review the pre-sentence report with your client?
Yes, Your Honor.
All right, and you do you have any additions or corrections or just scoring challenges?
No additions or corrections. Scoring challenges, and I guess maybe it might be an addition or correction, potential issue with one of the victim impact statements. I don't know how you would classify that, but.
Okay, well, let's see. I received written victim impact statements from a minor, we'll just use initials for minors, is that all right? Minor PW.
Yes.
And I received one from Ms. Barrison. That's one of the mothers. I received a letter from defendant's mother.
Correct.
And from his grandmother.
Correct.
So you're not talking about those two. Are you talking about the one from the adult victim impact statement?
Yes.
Okay. What do you want to say about that one?
Just that essentially the PW's mother is not a victim for these cases. She's not a complainant in either one of them. The complainant is PW. Because PW made her own statement and did not designate her mother to be making the statement on behalf, we would request that that statement be stricken. The adult statement be stricken.
Okay. Ms. Goodrich, your response to that?
Your Honor, technically by the statute, I would agree that because the victim wrote a statement, typically defense attorneys just allow the mother or the parent to also make a statement, but once the objection is made, then I don't really have a response to that because the victim did make a statement and stands by that.
Okay, so I will, obviously I read these when they come in, but I will disregard and strike anything in the written impact statement from the victim's mother and not consider any of those facts in the scoring of any guidelines.
Thank you, Your Honor.
Okay. So I do have the written statement from the minor victim. All right, and so why don't we go, we've got two charges. One, the accosting a minor for immoral purposes, which is scored at 5 to 23 months. And then using a computer to commit that crime, scored at 10 to 23 months. So maybe why don't we take one objection at a time. So give me one scoring challenge and we'll go from there.
You want me to, we've had a little bit of discussion about these at the prior ones. I don't know how much you'd like me to go over those again.
I guess I'd like a refresher then.
Sure.
So what OV or PRV are you challenging first?
Of course, thank you, Your Honor. We're challenging OV4 and OV, where is that other one? Forget the number of it, but it's the
OV10?
OV10, yes.
Okay, so let's do OV4 first. That's serious psychological injury to victim, and that was scored. Well, it wasn't scored in the accosting, but it was scored in the using a computer to commit a crime.
Correct, Your Honor.
Okay, and you believe that it should be scored at 0 points in both?
Correct, Your Honor.
And Ms. Goodrich, is your position that it should be scored at 10 points in both?
Yes.
Okay, so we're at all or nothing. And do you think that the argument applies to both charges, whether that should be scored or not? It should be uniform?
Well, I don't believe it should be uniform. I believe basically I would make, given that the prosecution wants the 10 points for both charges, I'd make it just, I would state the argument, say it applies to both, but I believe that.
Even if it scored for the accosting, you think it maybe shouldn't score for the computer crime?
Correct, Your Honor.
Okay, all right, so why don't we take sort of level one of that is tell me why it shouldn't score why it should score for neither of them.
Okay, perfect. Thank you, Your Honor. So OV4 is a offense-specific crime or offense-specific OV, and that's according to People v. McGraw. So when we look at OV4, and I know in particular it's the victim impact statement, right? So when we look at the victim impact statement, the complainant or the victim, PW, states that she has started or continued counseling and has increased her medicine for anxiety or some sort of diagnosis based on family members blaming her for Mr. Warner being in jail. Now, because of McGraw, we have to look at what did Mr. Warner do, and did that necessarily necessitate some serious psychological harm needing treatment? According to the complainant's own, or the victim, again, I apologize, the victim's own statement, it's based on other people putting these pressures or saying these things, not that anything Mr. Warner specifically did. And for that reason, it should be scored at 0 for both of them. The additional argument would be there's no additional fact that because he used a cell phone to text the complainant, that use of a cell phone or use a computer to commit a crime.
So under McGraw,
yes,
using a computer to commit a crime would not have resulted in serious psychological harm. So that even if it did score for the accosting, it shouldn't score for the computer. Is that your argument?
Yes, Your Honor. You've got it.
But that your broader argument is that even though the written impact statement would support that there has been serious psychological harm, that there's insufficient evidence on this record that has stemmed from the sentencing offense, that it has perhaps stemmed from post-sentencing offense conduct by people other than your client.
Correct, Your Honor.
Okay, Ms. Goodrich, what's the people's response to that?
Oh, Your Honor, I think that the being the victim of this offense had caused psychological harm, and being certainly a minor, difficult to explain, that but for his actions, she would not have to endure the consequences of coming forward and being honest and reporting him. This all stemmed from what he did to her that night, and I think that's just her explaining one of the things that happened as a result of that. You know, she calls him a predator. He's come at her 3 times prior, and she says, I've had to go to counseling weekly. I'm on a higher antidepressant, and then says because certain family members have blamed me. So certainly that's all encompassing of what she's had to endure as a victim, which is typical of a victim. I think that the device that he used in order to commit that accosting was the computer. So, but for him not having a computer available that night, he would not have been able to accost her and cause that psychological injury. So I think that was a vessel to create that psychological injury. So I think it should be scored 10 points for both.
Great, thank you. Well, I think what the prosecutor has articulated about the sort of the dynamics of sexual offense against a minor and what they might typically experience and how that sort of flows into when other family members don't believe that victim and blaming them, that can compound the harm. I don't take issue with any of that factually at all as a general matter and even as a specific matter in this case. However, the case law on OB4 is, I guess, both broad and tight at the same time, or narrow at the same time. It's broad in that the amount of evidence needed to score for serious psychological injury is not a particularly onerous threshold to meet. But there are some limitations that it has to be victim specific, and there has to be specific evidence that that particular victim has suffered a serious psychological injury as a result of the sentencing offense conduct by the defendant. People v. McGraw, the Michigan Supreme Court has cautioned that we cannot consider post conduct that occurs after the sentencing offense is completed. Also, the case law cautions trial courts not to score OB4 based upon sort of these reasonable victim or what a minor would typically experience under this circumstance, as the prosecutors articulated. Again, I don't disagree with any of that as a factual matter, but as a legal matter, that would be insufficient. We did adjourn this sentencing to allow for even testimony if the people wanted to present that. What we have is a written impact statement. And upon reviewing that written impact statement, it only establishes that the minor victim has had to go to counseling and change medications because, and then she gives the reason for that, and it is other family members blaming her for Keegan being in jail. I think on this existing record, that is insufficient to find on a preponderance of the evidence that the sentencing offense conduct by the defendant caused the serious psychological injury to the minor victim. So I'll sustain that objection, and OB4 will be scored at 0 points on both counts. All right, Mr. Andriaki, as to OB10.
Yes, Your Honor.
It's scored presently at 15 points in both counts for predatory conduct.
Correct, Your Honor. And we would challenge that and believe it should be scored at 0 points. Primarily because there's nothing here to establish any kind of predatory conduct in specific to these offenses themselves. The using a computer to commit a crime. There's nothing that shows that this complainant was, again, this victim was predisposed to sending or receiving, inappropriate pictures by use of a cell phone or through Snapchat. And additionally, as far as the accosting goes, there is, on a lower level, at the 10-point level, there is a relationship between the victim and Mr. Warner. They are related. So there is that. However, there is no exploitation here in the respect that She was with another person, another juvenile, I believe, at the time, and she refused to provide any kind of incriminating photos or anything of that sort. In fact, she turned around and reported the conduct, and which is why Mr. Warner is here. And as the statute and the case law discuss, the mere presence alone is insufficient. So for those reasons, we would request that OV10 also be scored, especially for the using. The accosting is a little bit, I understand, a little bit tougher for Your Honor, given that, you know, there is the 10-point difference there. However, especially when it comes to the cell phone portion, we believe it should be scored at 0.
Can I ask you,
Of course.
one complicating, or one question in my mind as I look at this with predatory conduct? That's defined as pre-offense conduct directed at a victim for the primary purpose of victimization.
Yes.
And the classic, I guess, situation for that is what's commonly referred to as grooming behaviors before the offense itself.
Sure.
And here, I'm not sure that there's a record of that until this offense occurred. With the major question in my mind, that your client has a previous juvenile adjudication for victimizing this same minor. That is pre-offense conduct to this offense. And does that constitute predatory conduct that kind of bootstraps into this case at all? Or does the passage of time, does there need to be some sort of continuing sequence of events?
Yeah, that's a very good question, Your Honor. And I think just shooting from the hip here a little bit on that. I'm
thinking from the hip.
Yeah. I think the like you had just mentioned, if there was some sort of, especially with grooming, you know, you notice some sort of, they befriend, they, you know, start doing these side jobs or whatever, and all of a sudden they're like a Boy Scout kind of thing, where they establish this relationship, and then over the course of 6 months, 12 months, they start amping up the sexual misconduct, right? I think when we look at this factual record, yes, there is the prior conviction, but there's nothing to show what happened between the prior conviction and today. What's the grooming conduct that's the supposed predatory conduct that occurred to lead up to this moment, other than that prior offense? Maybe there was something there, but I think, as you had mentioned, again, we have to look at the preponderance of the evidence, of the facts. It's either come through a victim impact statement, testimony, you know, through an actual oral statement, or perhaps something through a prelim or even a police report. We don't see that in this factual record. So I think that's a very good question. I think factually it could establish something to that effect. In this particular case, I don't see where the facts are there. So I would agree based on that. That's another.
And so you think that OV10 is properly scored at 0, not even the 10 points, because there's no exploitation? So if the accosting is sort of the soliciting or sending of something,
yes,
that then by your reasoning, that would never support, or on those facts would not support the exploitation of a vulnerable victim. I mean, there's plenty of times where accosting is pled down from other behavior, but if the accosting is truly the sort of soliciting, the without invitation, sharing inappropriate messages or pictures, and the solicitation of them to reciprocate, that conduct itself does not amount to manipulation for selfish purposes to constitute the exploitation. Am I understanding that right?
Yes, I think, in other words, I think there has to be an additional fact. So let's say, for example, let's get into a little bit of a hypotheticals. I think that might be helpful. I think if there's something, there's predatory conduct where a person goes out and, you know, they case a playground, or they know that the parents aren't there, or they already have some sort of cell phone, and they choose one family member as opposed to a second family member. That, I think there's a little different factual scenario there, where there is something over and above just the mere relationship or the age itself. Let's say, for example, there's a bunch of children at the playground, and a defendant chooses one out of that group of 5 kids because there's a younger person watching them and there's nobody, the parents leave or something. I think that sort of circumstance, definitely predatory conduct. Even there's 2 siblings back to back, they choose one because one of the younger siblings has something in their background, maybe a learning disability or something that they could manipulate to their own gain. I think in those sort of circumstances, an accosting would support points even under OV10 for predatory conduct, or even the youth agedness and so forth. In this circumstance, I don't see, there's nothing to kind of give more, I guess, context as the way I would kind of look at it as to that.
What about, I have one more question for you before we hear from the prosecution. And this is back to predatory conduct, pre-offense conduct. Why can't I parse out the messages so that the messages as it begins in the offense narrative, there's this message back and forth, what are you, he's reaching out, what are you doing? And then he's talking about his mood. He's talking about, he's making some references to, I guess his, he's sort of leading up to that he's got some sexual urges. Before he's asking her to be engaged with any of that, he's sort of leading the conversation in that direction.
Sure.
Why wouldn't that constitute the pre-offense conduct before the act? Because that's not criminal at that point. So then once there's the criminal event in the conversation, can I count the previous leading up to that moment as pre-offense conduct directed toward victimization?
I don't believe so, because I think it's all part of the same transaction or occurrence, so to speak. I'm trying to think when we see like the Chris Hansen kind of things.
They're doing some things on it because I've scored it in those cases. I've had a couple of those sting operation cases, and they stop along the way and they get some things, or they communicate with them several different times. So it's more than one conversation.
Yes. I think in that circumstance, arguably OV10 can get scored that way. I think in this one, especially too, one of the other factors here is she says, if I'm not mistaken, that she's with somebody else at the same time that he's sending these messages to her. And there's not it's not really even a back and forth. It's just he's stating these things to her and she's pretty much not reciprocating.
Okay. All right. Thank you. I think I understand your position. Ms. Goodrich, what's your
Thank you, Your
response?
Honor.
Thank you, Your Honor. I would ask that the court consider the case 2003 case, People versus Witherspoon, 257 Mishap 329. In that case, the defendant, it was an in-person assault case, but the defendant had waited till no other person was present. There was waited till the child was in the seclusion of a basement and watched the child and waited for her to be alone before the assault. So the defendant in this case is going to use a phone to commit the accosting. So what does he do? He uses the fact that he's a relative, that they have this previous relationship. She has been previously a victim of his actions. He knows her. He knows how to manipulate her. He waits till she's at a friend's house. He waits. There's no parent around. There's no other adults around. It's just only her and another juvenile friend. He then has the setting in any location. No, it's the location of the bedroom that she has at her grandmother's house. So he's in her bedroom when he's texting her and doing this accosting. He's laying in her bed to get her attention, to get her to engage in the conversation. He initially sends innocent texts to start getting her to talk to him before switching into the sexual conversation and sending the sexual pictures. These were all previously, I believe, contemplated pre-offense conduct and grooming her into getting her led into this situation. And so I think that the exploitation is properly scored at 15 points.
Thank you. Any rebuttal argument to that?
Not primarily, Your Honor. Again, Mr. I think we've discussed it. I wouldn't say anything additional. Thank you, Your Honor.
All right, this is, presents, an interesting question. The statute, the statutory sentencing guidelines for offense variable 10 are for exploitation of a vulnerable victim. And it's been scored by the Department of Corrections at 15 points for predatory conduct being involved. Predatory conduct is defined as pre-offense conduct directed at a victim for the primary purpose of victimization. And here, the prosecutor, I guess I'm persuaded by the prosecutor's argument presented here today that there were a series of choices and decisions and actions that the defendant made leading up to the criminal exchange on the text, with his placement of where he was, the exploiting that relationship, waiting until the victim was at outside of the her parents and her home, and then some of the messages leading up to the criminal parts. So I think that all of that is pre-sentencing offense conduct. It does involve a series of choices, decisions, and actions. They are directed toward this victim for the primary purpose of victimizing her with the accosting by the computer, which he did. So I think the prosecutor has laid out some pre-offense conduct that would support that score by preponderance of the evidence. So I'll leave OV 10 scored at 15 points for both counts. So I've sustained the challenge to OV 4 in the computer crime. So that would lower that from total OV 30 points to 20 points. So that would then be, get to the D grid here. That would be from OB level 3 to OB level 2. And that would then be, instead of 10 to 23, it'd be 5 to 23. Is my math correct, Mr. Andracki?
I believe so, yes, Your Honor.
Ms. Goodrich?
Yes.
All right, any other scoring challenges from the defense?
No, it was just OB 4 and 10, thank you.
Any scoring challenges from the people?
No, Your Honor, thank you.
Okay, Mr. Andriaki, any allocution you want to make on behalf of your client?
Yes, thank you, Your Honor. I think when we consider this case and Mr. Warner as a whole, unfortunately, there's a significant amount of substance abuse history for him. If you give me just 1 second, I apologize, Your
Sure.
Honor.
I'm sorry, before we get rolling on that, can you help me calculate what jail credit he's allowed as to today? I think I had calculated 239 days back to the October 21st day that we were at. Has anybody done the math to see what credit he's entitled to today?
I have not.
Okay.
I have that now.
Let's establish that before we get rolling on the next part here. So up through January 28th would have been 189 days. So now we've got from January 28th to November 25th. Rather than look at the calendar, why don't I just grab a date calculator? What I'm going to do is I'm just going to put in the start date at the February 10th, 2025. And, oh shoot, that is not right. And I have to put the days in. I don't get two dates. Oh, start date and target date. Here we go. All right, I'm using the Michigan Court of Appeals date calculator with a start date of February 10th, 2025, and a target date of today, 11/25/2025, and that says 288 days. Any objection to using that for the credit days?
No, Your Honor, that's consistent with the jail list today.
Oh,
No objection, Your Honor.
oh, man, I wish I would have just asked you that. I would have, at least I didn't have to do math. All right. All right, I'm sorry. Mr. Andraki, go ahead with any elocution.
Thank you, Your Honor. When we look at Mr. Warner's, obviously, being sentenced on a using computer to commit a crime and a costly charge for moral purposes, obviously, they're not great crimes to be sentenced on, right? We all understand that the name of them, the conduct that predates them, that leads up to them, the sex offender registration, everything that goes into that. Mr. Warner's going to be living with this for the rest of his life, including with the registration. The primary thing here, when I look at his, first, the letters that were in support, and second, when I look at his adult history or even juvenile history in a PSIR, Mr. Warner does not have a significant incarceration period from what I'm looking at here. He does have family members in support. I do believe that with 5 to 23 and 2 to 17 on the accosting, you know, it comes down to.
I've got 5 to 23 on them both.
I scored the accosting at 2 to 17.
I think that was if you won on OB10.
Maybe I misscored it. So it's class F. And looking at the PRVs are 35, the OBs
are 20.
Oh, you're correct. Yeah, OB 35 and 20. So let's go to class F 35 and 20. Yeah, you're correct. I apologize, Your Honor. It is 5 to 23.
Okay.
Sorry about that.
That's fine. That's fine.
You know, it comes down to a prison sentence or a jail sentence at 5 to 23. And I would note, yes, that there has been a previous conviction involving this complainant previously, this victim previously. Mr. Warner, unfortunately, he's a young man, 21, 22 years old, has racked up a significant criminal history. We would request a jail sentence be imposed primarily because all the factors in here have been considered previously. So the fact that he's previously had a case involving this complainant is included in his PRV scoring. The facts of the circumstances of the actual conduct here is scored in the OBs. He does have family members in support that will do whatever they can to try to help him stay on the straight and narrow. I do believe that, again, he doesn't have a significant incarceration history. 12 months in the county jail would obviously teach him a lesson on these, with all that considered. And I do believe probation and oversight would be appropriate for him too, given the substance abuse problems that he has. Essentially, this case comes down to a substance abuse issue. He does have, when we read through there, he was intoxicated and sent these messages should have never sent. So for all that considered, Your Honor, we would request a jail sentence of 12 months in the county jail.
All right, thank you. Mr. Warner, it's not required that you don't have to say anything today, but you're welcome to. Is there anything you want to tell me or no?
I just want to say I regret what I did. I was going through a really rough time. I used my phone to do something I shouldn't have done, and I should have thought it through and not did it.
Okay, thank you, sir. Mr. Goodrich, any recommendations from the people?
Oh, yes, Your Honor, thank you. The defendant is 22 years old with 1 felony and 1 misdemeanor and a juvenile record. He's unemployed with an 11th grade education. What the guidelines don't take in consideration is that he has re-victimized a previous victim. The guidelines don't take in consideration that he was on probation for the same offense when he committed this accosting, all at only 22 years old. He has quite the history. The family member support that we're discussing is the same family members that are giving the victim a hard time, making her feel awful for telling the truth and coming forward. I would ask that the court sentence him on top of the guideline range at 23 months.
All right, thank you. All right, after the sentencing offense, he committed an offense, a similar offense for which he's on probation, correct?
Yes, Your Honor.
Oh, okay, so he wasn't
Oh, I
on
had that
probation at
backwards,
the
I
time of this
apologize.
offense, but subsequent, which is relevant factor. Okay.
Thank you.
All right, Mr. Warner, if you please stand for the court sentence. All right. Mr. Warner's 22 years old. He's got a prior felony, 1 misdemeanor, and juvenile history. He's here for sentencing on the offenses of accosting a minor for immoral purposes, for sending inappropriate messages and photographs to her and asking her to do the same, and using a computer to commit that crime. The advisory guidelines are scored at 5 to 23 months on both counts. There is discretionary consecutive sentencing that's authorized by the computer crime statute. In this case, Mr. Warner's history is what's most concerning. He has a juvenile adjudication for accosting and indecent exposure in 2016, involving the same victim as in this case when she was 7 years old. And now as a teenager, he's victimizing her a second time. And then also after this offense, the offense date for this case was October of 2024. In March of 2025, Mr. Warner engaged in similar conduct in Emmett County. A different victim, still related to him, and about 12 years old. And he's been sentenced to probation with a jail term. I think the prosecutor makes a good point that the guidelines, although they take into account the prior or subsequent convictions, they don't take into account the disturbing pattern here of similar sexual crimes, now 3 of them. They don't take into account that he's victimized more than one victim. And they certainly don't take into account that he has now victimized the victim in this case for the second time. Once when she's 7 and then when she's a teenager. This shows that this is beyond an alcohol problem for Mr. Warner, that he has a serious issue with being a predatory sex offender, victimizing minors that are related to him, more than one, and more than 2 victims, and one of them victimized twice that we know of. There'd be a pretty good argument that those factors aren't taken into account in the guidelines and there'd be grounds for an upward departure. But given that he's got no prior record, that these offenses didn't involve actual contact with them, I'm not sure that I'd want to do a departure sentence. I certainly do agree with the prosecutor that I think upper end is a proportionate sentence here. So that there's $136 in state cost, $130 in a crime victims assessment, $350 in court costs. Mr. Warner has been registered with the Sex Offender Registration Act. He has to comply with that. And on the charge of accosting minor for immoral purposes, I'm going to commit Mr. Warner to the Michigan Department of Corrections for a term of not less than 23 months, nor more than 4 years, with credit for 288 days previously served. And for the using a computer to commit a crime, I'm going to commit him to the Michigan Department of Corrections for a term of not less than 23 months, nor more than 7 years. And I'm going to give him 0 days credit on that and exercise my discretion to impose consecutive sentencing. I think that strong medicine is required here, given his disturbing pattern of victimization, as I've outlined on the record. So that's the sentence of the court. Mr. Warner, you're allowed to, you may file an application for leave to appeal your conviction or my sentences or both. If you wanted a lawyer appointed to you, I would do that if you requested within 6 months of today's date. We're going to hand you a piece of paper explaining that appeal right and ask you to initial 1 copy for us. So we have a record, we gave it to you. The other one is for you to fill out if you wish to take an appeal. All right, good luck to you, sir. Thank you, Mr. Andre.
Thank you, Your Honor.
That concludes our docket. We'll be
Let's see. Hopefully he gets. I haven't seen John ever since this debacle with the the trailer or the RV or whatever it is. I haven't seen him. He hasn't been in here. Gail comes in every once in a while. So does EMS come in every once in a while. But this double format thing is a pain in the ass because it means I have to set up 2 YouTube live streams. But they both get views, so I don't know. I'd rather go back to the single format. It's a lot easier to do it. Yeah, I miss it a little bit. I just want to say that I hope that I hope that what happened to me doesn't happen to somebody else. And Trin knows what I'm talking about. I give it time. I hope it doesn't happen. And I found one of Trin's old emails that she sent me a long time ago. I printed it out and I used the other side of it, so I kind of read it. I agreed with what she said. Yeah, that's what I mean. Yeah, I could see that, Trin. It's not that much of a problem. I just had to schedule. Better not be smoking. I'll beat the shit out of you. Yeah, I slipped a couple days ago, man. I smoked about a couple packs of cigarettes. It lasted me for 4 days. But the first time I smoked that cigarette, it tasted so stale, like it was stale. I know they're fresh cigarettes, but it's because of the medicine. I had to stop taking it because it's been making me sick to my stomach. So Thursday, Friday, yeah, today, that makes 3 days I haven't had a cigarette today. Yeah, I don't understand. I don't understand why somebody else, and then their channel got bigger. And their channels got bigger because of it, what they did. It boggles my mind that these people do shit like, if they want to talk about what's going on with what the hell, go ahead. I stopped talking about it because it was just, I sit there and have to listen to the two fleas live streams and take notes. It's just time that I don't have anymore and time that I won't take anymore. Yes, some of those videos got views, but the thing is, it's not worth the time anymore. It's not worth the hassle or the stress to sit there and listen to them completely lie. I hope so. I hope so, Trin. Yeah, the whole thing is you have to sit there and listen to them lie for 2 hours. And see, the funny thing of it is, they don't have proof. I will say this: she's nothing but a damn liar anyway. If you had proof, what proof do you have that Jeremy stole the memorial? You don't, okay? You have blurry pictures that could be 150 different trucks pulling up and stopping. You don't have any proof that it's Jeremy. Yeah, but the thing is, if I was Judge Gob, whatever his name is, all this BS that's going on right now would stop. In my opinion, I'd have, what I would do as a judge, if I was a judge on this case, is what I would do is I would tell Randy to file a motion for a default judgment. And when he filed the paperwork for a default judgment will go against all of them. If they tried to stay it or whatever, I would deny it. It's just stall tactics. Just stall tactics that are costing Jeremy a bunch of money, and I don't think that's fair to him. I don't think that it's just stall tactics, and I don't understand why these judges don't see that. If it would have been Judge Simpson or Judge Middleton or Judge any of these judges that we talk about on this channel, they wouldn't put up with it, especially Judge Webster. They wouldn't put up with the stall tactics. None of them would. I know Judge Simpson wouldn't. I just, it's like I said, if I was a judge, I'd stop all the damn stall tactics. I have a default judgment against all of them. Another thing too, Mr. BBB didn't show up for a court hearing. He is now legally in contempt of court for failing to appear to a court hearing. He would get I'd give him at least 10 months in jail, at least. I give him a little bit of jail time, let him have a taste of his own medicine. And then I would sanction BBB. I don't understand why these judges are doing this. Because it's a YouTube thing? I don't know. I don't understand that part of it. Yeah, I agree with you, Trin. I agree with you, Trin. I really do. This whole thing is just and I agree with Gail. I agree with you that this whole thing just got out of hand really fast. Now you watch Judge Simpson. You go back to Judge Simpson when I did Judge Simpson this week. Somebody didn't appear in court. Guess what? He issued a bench warrant for their arrest. Yeah. All these channels are making money, but this channel can't make enough money. Can't make any money. If I do a give send go to help pay for the expenses of this channel, I'm a grifter. Even though this channel is not monetized. I mean, $45 a month just for StreamYard. Then I'm paying $56.60 for T-Mobile internet. And thank God, I love T-Mobile internet. I have had no problems since I've started with them. And the price is just reasonable. I've had no problems with T-Mobile home internet. It's affordable and it's reliable. I don't know how many outages Spectrum has had. I'm sure they've had some. Oh, and anyway, if they want their equipment, they can come and get their equipment. I'm not spending all that money on a taxi ride to a Spectrum store to turn in my equipment. They can come and get their equipment. Simpson would have. Yeah, exactly. Yeah, quite a few of these judges too. Judge Webster wouldn't tolerate it. I don't even know when Judge Webster comes back on again. I think it's this coming up week. Let's see. I have to look for. I can't believe that November is just about gone. So that'd be Wednesday on the 3rd. Tuesday, I'm doing a thing about sovereign idiots. Monday is the landlord-tenant docket. I can't believe this month is gone already. I hope so, Gail. For this guy's sake, and Judge Belitho's sake. But still something that goes through my mind every once in a while is I had printed a copy of that indigent status that she filed. And the other day when I was cleaning out junk and getting rid of a bunch of junk and old paperwork and stuff that I don't need anymore, I found that copy of the indigent. And still to this day, the math doesn't add up. Even the math in the bankruptcy doesn't add up. If you try to use bankruptcy to get out of what you did, it's not going to work. And I think that filing for bankruptcy is a cowardly way. Oh, that channel is garbage. That channel is a garbage channel. You talk about the two fleas. All they do is lie. All they do is lie and make up shit. How many times in the last 6 months they say, "Oh, we're going to get Jeremy arrested," but Jeremy's never been arrested because you don't have proof. It's the same thing every fucking time. You do not have proof of any of the accusations that you have against Jeremy. And yes, I said the F word because guess what? I don't care. Oh. Now I forgot that joke. It was really funny. Okay. This is the joke. What do you call it when someone farts in a gay bar? A meeting call. All right. Yeah, and they're writing everybody else's too. They're trying to make themselves relevant. But once all this stuff ends, all this whole thing ends, there can be nothing to talk about anymore. It's just a matter of time when all this stuff ends. Nobody will have anything to talk about anymore, and a lot of that content will be gone. People are going to get tired. They're going to move on and go to somewhere else. I decided to move on a long time ago because everything that I was doing wasn't working. So, seriously, Gail, it's going to seriously bite her in the butt. It's going to seriously bite her in the butt. Yep. So let me look up something really quick. It's a trying to see something. Okay, it's a shell thing. Florida, it's still active. Okay, so her 501(c)(3) was refiled on 10/18/2025. So her 501(c)(3) was refiled, and her status got it got redone on the 18th of October of this year. So I don't know if she did it or somebody else did it for her. I can't remember what that other one was. I know one of them was, what do mechanics and lesbians have in common? Snap-on tools. I gotta stop watching them things on Facebook. Yep. A lot of channels, a lot of them will. And this one will still be here. Even though it looks like Judge Gauthier is, I would look at the playlist and not that many videos left. But, if you guys know of any judges that I don't have or don't talk about, please let me know. Now, I know I got Judge Manning out of Fulton County, Florida, or Fulton County, Georgia. I still got a bunch of Judge Webster. I got a bunch of Judge Simpson. I got a bunch of Judge Fletcher. I like him. I like Judge Fletcher. I love Judge Fletcher. I love Judge David Fletcher. I don't give a rat's ass if Mother Teresa is late for church. Do not drive. Yes, Judge Simpson and Judge Fletcher are my favorites too. Judge Boyd is okay, but she tries to be sympathetic, but she also puts on the law too. Oh, excuse me. Middleton is okay. It seems like they're a little bit lax in that part of Michigan about certain laws, especially DWIs. Some state, I know New York State, they'll lock your ass up. They don't give a damn. I know New York State will lock your ass up. I know Birmingham, they'll lock your ass up. I also saw something on MG Law's thing that portrayed a Birmingham police officer abusing their power. Yeah, they do abuse their power. I will say this, at least Birmingham police do their job. I can't say that about the Levy County Sheriff's Office. That's a shame. When you took that oath to serve and protect. And that means Jeremy and George and anybody that lives in Otter Creek, who lives in Levy County, period. I did do that for a while as a consultation, but I'm not worried about it. I really want to stay retired. I really don't want to do any more computer stuff. Anyway, this place is not my home. This place isn't my home. My home is, oh, I consider a home a place of privacy. And since I live in a Section 8 apartment complex, I can't have people come and bring their computers to me. Oh, they're not, they abuse here, but most of these police officers are pretty good. Every time we talked about that, now I wonder what the two fleas are going to lie about tonight. I gave John, I'm not a lawyer, but my advice to John is, John, if you're listening, you need to sue the two fleas. They raised money in your name and in that little girl's name, and she took your money. You need to sue her. You need to make the file. You need to make those complaints. You don't make those complaints, you can't do anything. But that's going to be it for today, ladies and gentlemen. I'll be back tomorrow. I'm here every day at 3:00 p.m. Central Daylight Time, 4:00 Eastern Time. I have no idea what time in California. Tomorrow is our miscellaneous cases docket, which is just a bunch of different judges in different courts and stuff like that. Yeah, I did find quite a bit. I have quite a bit of the UK Supreme Court, and that's going to be interesting. It's going to be interesting to see how the UK Supreme Court does their job. So I got plenty of video content for that. But you all have a good evening. My tummy is not being nice to me today. But you all have a wonderful evening. Ciao, ciao, and ta-ta, and I will see you guys tomorrow for our miscellaneous cases docket.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right when I'm falling apart. You put me back together. You make it better. From the wires tangled up to the broken dreams. You know how to man all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright when I'm falling apart. You put me back together. Daniel, you make it better. Fix it, Daniel. Fix it, Daniel. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Aaron, touch, everything's okay.